Hello friends, welcome back to a new video. Today's session we are talking about the new bill that was tabled by the cabinet of the Karnataka ministry, which is giving the right for the state government to determine the quota of 50 percentage for the managerial positions and 75 percentage for non-managerial positions in the private sector in Karnataka. That includes the IT sector as well. So this much of reservation is given for the Kannadigas. Kannadigas, in the sense, the people who have domiciled in Karnataka at least for 15 years and who has something like a secondary school leaving certificate, or they have to be clearing an exam conducted by a nodal agency which has that basic Kannada of reading, writing, and all those stuff. So the purpose of this session is basically to understand the constitutional and legal validity of it and the repercussions of this particular bill. Along with it, the government has come up with a proposal to give 100% reservation for Kannadigas in Group C and Group D government sectors. Okay, but our purpose is mostly on the private sector, in particularly the IT sector. And quite recently, the government has actually, you can say, freezed this bill, considering the amount of pressure it got from the various business groups. So the thing is, first things first. The thing is, can government do this on its own? And what is the course of action in which government can achieve it? And I will obviously tell you my stance on this particular bill, and on final, and what happens if this becomes a reality. So these are the things that we are going to discuss. So at first, I will tell you my stance. I will say that this is a highly disappointing thing by the Karnataka government, not just Karnataka government, and this tendency should be nipped from the bud, because this kind of subnational regional tendencies will have a very bad impact on the Indian Union, because we are talking about the citizenship in a union. We cannot think that Karnataka or certain other states can be treated like some separate countries where you need to go there and have a work permit to work there. That will be utter nonsense, and it is not in favor for a unified country. This kind of subnational tendencies, you can say, have been earlier propped up by governments like the DMK, or as a counter reaction to it, you saw that Bal Thackeray and Shiv Sena in Maharashtra, and such kind of acts have been passed and which were struck down by the court. For example, in Haryana it happened, and also it happened in Telangana, but certain things were struck down by the court. But before going into the details of the bill, first of all, I will have to tell you that such kind of reservation for the local tribal communities of certain things are prevalent in Indian states. In certain northeastern states, it is prevalent because they have been given special provisions under the Article 371 plus. You can see like A, B, C, D. Certain provisions are there, and even in Karnataka, you can see Hyderabad, Karnataka given a provision under 371J. Okay, and there is historical reasons for it. There are certain other geographical considerations for it. But here, what the government has said is like reservation in favor of a domicile. In India, what you have to understand that there is reservation, and that is because there has been some historical wrongs done to certain communities, say scheduled caste, scheduled tribe, or even certain other tribal communities which are very less and which they needed protection. For such purpose, in a way, the government is providing a helping hand, and the purpose of reservation is rather than economic, it's kind of a social upliftment, and the government is giving them say in the government service, or even in, say, legislature, or in the case of election. That is the purpose of reservation. First of all, that is the angle in which the court and the commissions look into when it comes to the reservation. Now here, what the government has come up with is like a son of the soil kind of a scenario, where based on the domicile such reservations have been given. Okay, now first look into our fundamental rights. So I am directly going into Article 16.1. So here, there it talks about reservation in the terms of employment, but there also it does not say. It says about certain like relaxations for the religious institutions, certain things, and endowments or institutions owned by the religious groups, and based on caste, based on religion and say certain things, but there has not been something based on domicile, first of all. So this could be one of the reasons why such kind of laws could be struck down by the court earlier. Okay, so just say if the this law is is put into vote, the Congress government has the majority, so just a simple majority would do in both the houses, since Karnataka also has a upper house in the form of Suvarna Sauda. Even if say there would be some rejections on it, but in a common sitting it would be passed. And if it has to become a law, it has to be signed by the governor, which is the executive head of the state. If the governor refuses to sign it, and if this bill is being sent to the president for the presidential assent, and the president has the right for absolute veto on this bill, okay, that is when this bill will not become an act and it can become the end of the bill. Okay, that is one thing. Other thing is that if the governor signs it, it will get implemented in the Karnataka, and the government can technically implement the bill. There is no problem with it. Okay, now I'm going to answer another important question. See, at present, what is the status quo? If you look into it, see, majority of the IT companies and all, you never seen a scenario in which the 75% of the managerial position is for the Kannadigas and 50% of non-managerial position. You may not find any company, maybe very small scale companies, it could be there, but most of the corporate, you don't find such a kind of a scenario, because the talent is not just limited to one particular ethnic group or one particular language group. And Bangalore is a cosmopolitan city where people from each and every part of India is there. It is just a microcosm of India as a whole. So if this happens, what will happen to the existing scenario? Many people fear that the existing people may lose their job, or a situation will happen like the companies will have to reshuffle their managerial and non-managerial positions. I will say that even if the law is passed, it will not happen. Why? Because I will I will take you to the Article 20 bracket 1, the fundamental right that talks about there is no retrospective punishment. Okay, I will explain what it is. Because if a law is passed, just say that by the time the law is passed, somebody might have committed some crime. It's not a crime. By the way, the tradition is, if we are actually in a way violating the law, even when the law is passed, just because something that happened in the back is violating the law, you cannot be punished at present for that. That is the reason why there is no retrospective punishment. I will explain it a little further. For example, say in 1955, the Hindu Code Bill was passed. Okay, technically that way polygamy is not allowed in the Hindu society. Okay, but you can say there were certain people at that time with two legal spouses. But just because that act was passed at that time, that didn't mean that they had to divorce their wives. Like even if they had more than two wives. After that law, it has to follow whatever that is said in the law. I'll tell you two examples where the people were with the multiple spouses, technically from the Hindu community. One was Muthuvel Karunanidhi, the ex-chief minister of Tamil Nadu. Another one was Ramjet Malani, the famous lawyer. Both of them were born in 1922 and 23, and by the time this law was passed, they had actually married twice. So they were not punished for that, right? Even when, I'll tell you another example for certain political parties, you have the Indian Union Muslim League. Okay, but when you say about the Representation of People's Act that was passed in 1950 and all, you cannot, after that you cannot name a political party based on religion. But this political party of Indian Union Muslim League was formed before that. It was formed in 1940 March 10th. So that's what I'm saying. Even if just say this law is passed, okay, the existing status quo will not be reshuffled. So if a new company is being registered, they may have to very well follow this law. So that is why I am telling you how the constitution is dealing these things with. So there is a natural justice within the constitution that can act as a safeguard for this kind of a scenario. Okay, so now the thing is, what will happen in the future if this law has been passed? There has been always a tradition in India where the court has always talks about something known as the basic structure. This basic structure doctrine has been formulated by the court through various judgments starting from 1973, which is the Keshavananda Bharati case. So in this scenario, the court will always look into constitutional court. I am talking about high court and above supreme court, not the lower courts, which are not which does not have a constitutional provision as such. So when the constitutional court and a constitutional committee is analyzing it, if they find that these kind of fundamental rights are getting violated because of this act, it can very well strike down this. That is a kind of a judicial review system that has been there. So at the same time, one case that comes to my mind is the Indira Sahini case in 1992, which talks about the reservation cap being at the 50%, and this has very well violated it. Now it's staying like 50 percentage in the managerial position, and even 75% in the non-managerial position. And even when the company is not able to find people for that, they have to actually get back to the government, and the government will say, okay, at the most you can actually make it 25 and 50, 25 percentage for non-managerial and 50 percentage for, sorry, 25 percentage for managerial and 50 percentage non-managerial. So what I am trying to tell you is, because of the judicial parlance, the certain cases like this Indira Swahini case has certain relevance on this particular act. And also the fundamental rights of article 16 as well as article 20 very well states that such a kind of a law has every chance of becoming stricken down as like a non-constitutional law. So my now the next question comes to my mind is, see, if a layman like me can tell these things, do you think that the government is actually not knowing these things? No, the government would be obviously knowing these things. So I very well believe that rather than making it a case of an act that they wanted to actually put it into practice, this is mostly looking like an election gimmick, where the government is actually trying to hide certain of its downfalls through such an act, like flaring up some local sentiments and son of the soil sentiments. But that is not going to be a good scenario for India as a whole, because just imagine if every state thinks like that, and if every state, like say Karnataka, rather than Karnataka, is say Telangana, Andhra Pradesh, Kerala, Tamil Nadu, Gujarat, Maharashtra, if every state will if they pass certain laws like that, India would be balkanized. There won't be a country like India, because every state will act like some independent countries. This would be something like a European Union or a confederation, even worse than European Union, because European Union you do not have this kind of a discrimination going on. So I believe that this law is unconstitutional, taking into the previous judgments like Indira Swahini, and also looking into the Article 16 as well as Article 20, and also looking into the future of the country as a whole. This kind of a scenario of the reservation based on domicile should be nipped from the bud. There should be many other ways in which the local people can be compensated, but not through this, especially in the private sector, because giving relevance to the government sector, and that too for certain communities which have been historically discriminated, that is a purpose of reservation, not to actually thwart the talent and destroy the private business. Then the country would look more like a military republic, not a democratic republic. So that is not the country that our constitutional framers dreamed, and that is not the country that anyone with bare amount of common sense would like to have. So this is what I want you to understand and think about. Have a nice day.